Hi, everyone. I'm watching our attendee count rise. I'm going to wait just another awkward minute for all of us. So hi, everyone. Welcome. I'm going to go ahead and start us at 6:03. I'm Mark West. I'm Dean of the Law School. It has been a tumultuous and in many ways unprecedented election cycle. And certainly the events that have unfolded in the last 24 hours have been no different. Our programming tonight is titled Certifying the Vote, When Courts Get Involved in Presidential Elections. It turns out that this is a highly relevant topic, or at least it is said to be. So tonight, I'm delighted to introduce two of the University of Michigan's and the law schools experts on elections and courts to walk us and talk us through some of the issues. Samuel Bagenstos is the Frank C. Miller Professor of Law, and Ellen Katz is the Ralph W. Egler Professor of Law. To condense Sam's career and throw it in a blender a bit in a way that kind of minimizes a career of public service and academics, it looks something like this. Sam clerked for Justice Ruth Bader Ginsburg, was the #2 official in the Civil Rights Division of the Department of Justice, and has extensive experience in constitutional and civil rights litigation. He has argued 4 cases before the Supreme Court. Sam also reads everything. One of my favorite Bagenstosian expressions is, I haven't read much in this field, but from what I understand, followed by an exposition of everything that Sam understands beyond everyone else in the room. And to do a similar and brief disservice to Ellen's illustrious career, she clerked for Justice David Souter, and her significant research includes a highly influential study of litigation of the Voting Rights Act. And by focusing on that one study, I unfortunately discount all her other work, as well as the fact that she is the leading voting rights scholar in the country. And I want to be clear about that. There's not a competition. She is the leading voting rights scholar. And we're really fortunate to have at Michigan these two experts who intimately understand the electoral process and the role of the courts, including, of course, the Supreme Court, if it comes to that, can play in determining the outcome of presidential elections. So please join us for a conversation between Sam and Ellen, which will be followed with a period of questions from you, the audience. We ask you to submit your questions using the question answer feature, and we are recording. And now let me get out of the way and turn the virtual stage over to Ellen and Sam. Ellen, Sam?
Terrific. Thanks, Mark, for that too gracious introduction. And to Catherine for putting this together, and the other Mark for the tech support in getting this set up. It's great to be here virtually. It's nicer to be in person. And I always enjoy having an opportunity to have a conversation with Sam. Of the very many things I miss about our present existence is the opportunity to bump into Sam in the hallway and hear his views on matters arising, which are always informative and often quite funny. So we're here, we're gonna talk a little bit, we thought a little bit about how to organize this, but it's really just gonna be a conversation. And I think one of the places to start is just how a presidential election itself offers us a moment to sort of think about an election as a civics lesson at a very basic level, and the extent to which it sort of highlights aspects of how elections are run that are news to some people, reminders to others. And I think one of the big things that we've learned in the last couple of days is that announcements of winners on election night are always projections, not certifications of winners. The counting always goes on afterwards. It goes on in the roughly half of the states that still accept ballots after election day. But even in the states that have a firm cutoff on election day, counting continues in various places. And we're seeing that going on right now. And I know that's a source of lots of worry and anxiety for lots of people, made somewhat worse by technology and our constant pressing of that refresh button to see what has happened, and by social media that sort of makes this a relentless nonstop process. But it is definitely just part of the process and an expected part. It always has been, always will be. It also exposes, I think, the very decentralized nature of elections in the United States. 50 states, thousands and thousands of local administrators implementing various rules, and the rules vary quite dramatically from jurisdiction, from state to state. Some states, you have to register to vote in advance of the election. States like Michigan allow you to do it to register and vote in the same day. Some states have rigid voter ID requirements, others do not. Some states rely exclusively on vote by mail, 5 states, and now we've seen this massive increase in absentee voting throughout the country. Some states like Michigan allow absentee ballots on demand. Others continue to require excuses and reasons for them. And this gives rise to wide variation in practice and also lots of disagreement about what are best practices and different understandings of what fairness requires and, in fact, what the law and the Constitution itself requires about these things. We're going to talk a bit about the litigation that's developed, and I'm going to hand it over to Sam to talk a little bit more just about the groundwork of the Electoral College, how that works, what's going on in Nebraska, Maine, why that looks a little bit different, and then what we may expect in the coming weeks in terms of the certification of the electors, the voting of the Electoral College, and so on.
Yeah, so that's great, and I do want to thank you, Ellen, for having this conversation with me, and I completely agree that one of the things I miss the most about our life in this sort of pandemic times is that we don't run into each other in the halls, and that's one of the nice things about the University of Michigan Law School, and so this is a small and very public version of the kinds of conversations that we would normally be having extemporaneously when we happen to be grabbing a cup of coffee or something like that. And so I really appreciate the folks who pulled together this venue. So when we're talking about presidential elections, of course, we're not talking about a direct vote for the president, right? Everyone knows we have the Electoral College, so people vote in their states, and technically you're not even voting for the presidential candidate, even though on the ballot it will probably say the name of the presidential candidate you're voting for. Technically, you're voting for a slate of electors who are pledged to vote for that candidate, because in the compromise that created the Constitution, obviously we created this system where each state votes a slate of electors equal to 2, including, for representing the number of senators they have, plus the number of members of the House of Representatives they have. And in most states, those are awarded on a winner-take-all basis. So whoever wins the state wins all the electors in the state. That means it's very, very, very important for presidential candidates to go to big states and swing states and to win those. It takes, as we all know now, 270 electoral votes to win outright. It takes a majority of the electoral votes. And so to assemble that 270, right, what you want as a presidential candidate is to get as many of the seats that are in play, of the electoral votes that are in play, as possible. That means amassing as many big states as you can, and then the ones that can be flipped, there's going to be a lot of focus on. And that means states like Michigan, that have a fair number of electoral votes, we have 16, as well as are very closely divided, are places that get a lot of focus. But there are some states that actually get more focus than you'd think, because they don't award their electoral votes on a winner-take-all basis. And that's what Ellen was referring to about Maine and Nebraska, where they give 2 electoral votes to the statewide winner, and then in each congressional district they give 1 electoral vote to the winner of that district. And so what that means is that creates an incentive for presidential candidates. No Democrat is going to win Nebraska in this day and age, but a Democrat could easily win, and Joe Biden is almost certain to win, the congressional district around Omaha. So that's why you might have been surprised to see Joe Biden actually appearing in Nebraska toward the end of the campaign. And this is all going to determine who's going to assemble that 270 vote majority in the Electoral College. And so because it's the Electoral College, right, we have in presidential elections a process that goes on beyond the counting of the votes that's going on right now. So what's going on right now is we have the counting of the votes. If it's close enough, there may be recounts, but all of that then leads to a moment where the state will certify who won the popular vote in the state, and different states have different ways of doing that. At which point, if that happens before December 8th, which is the so-called safe harbor deadline in federal law, and the governor sends a slate of electors matching those winners to the federal government, at that point, we sort of know who the electoral votes are going to be cast for. Back in 2000, when we had recounts and litigation slowing things down, and it looked like we would go past the safe harbor date, which I think that year was December 12th. What the Supreme Court said is, no, the Florida legislature really wanted everything to be resolved by December 12th. We'll see this year a lot of the litigation that we're likely to see, if we see extensive litigation, is going to be geared around the December 8th safe harbor date and determining whether a count can be finalized in enough states to make 270 electoral votes by that date. As of today, it's looking very likely that we're going to get to clear electoral votes amounting to 270 votes by December 8th. But, you know, a lot of this depends on the incentives of the different parties to litigation. And, you know, this is a very strange year because of all of the changes that have been created by the pandemic, right? So Ellen talked about how a number of states have adopted mail-in voting. You know, in Michigan, we adopted no excuse absentee voting beginning in 2018. So this is the first election cycle where we have that. Everyone expected that there would, as a result, be more mail-in voting in this state. Because it's a convenient option for voters. But then COVID happened, and for health reasons, an enormous number of people want to vote by mail so they don't have to be in a crowded polling place waiting around with a lot of folks who might pass the virus on to them or whom they might pass the virus on to. So we saw this incredible shift, much more than people expected in this state and in other states, to mail-in voting, which then imposed pressure on the Postal Service at a time when the Postal Service was being defunded and changed in various ways. And that in turn put pressure on the rules governing the receipt and return of mail-in ballots, which led to some litigation that we're going to talk about. Other issues that arose from the pandemic, which also led to litigation, involved, well, what do you do when polling places are in locations that are too small to be safe for social distancing in a time of COVID, or it's impossible to recruit enough poll workers to staff the number of polling places that you used to be able to, because many poll workers in America are retired individuals who are in various high-risk categories for COVID and might not want to work the polls this year. And in fact, many didn't. And so we ended up with changes to where polling locations were, consolidation to polling locations. We ended up with the institution of drive-through voting in more places, so moving the polling place essentially outdoors so that no one had to wait in line. We had various rules regarding whether people had to wear masks in polling places, either poll workers or voters. And various other kinds of issues relating to the pandemic, all of which created opportunities for litigation both before the election and now post-election day. And let me see if Ellen would like to talk a little bit about the kinds of election we've seen in advance, or kinds of litigation we've seen in advance of the election, and what we're beginning to see right now to kind of tee up the question of where we go from here.
Or yeah. I mean, and I think one of the things to keep in mind when we sort of talk about all the changes that the pandemic created for existing election law, that we have seen amidst lots of litigation, lots of disputes, also thousands and thousands of election officials, state and local, working in good faith to try and make this work. Not everybody, but lots and lots of people working in real time to adjust to unprecedented conditions and process millions of ballots in circumstances that they hadn't done before. And so, you know, that's good news as far as that goes, on how well folks did in lots of places. Of the issues, and Sam has flagged a few of them already, that have generated litigation, I think what has generated perhaps the most consistent litigation in both federal and state court has been this question of, what do you do about ballots that are mailed in but are not received by polling places by election day, close of when the polls close? And some states have affirmative provisions in their law that allow for the acceptance of those ballots for days afterwards. Some states do not. And from the very beginning of the pandemic in the primary season, we saw this as an issue of great contention. And the first case that was teed up came out of Wisconsin, where Wisconsin just was inundated in March as COVID was expanding in that state and nationwide, with requests for absentee ballots at a volume that the state had never seen before. And as the primary election in April got closer and closer, it became clear that lots of people who had requested absentee ballots would not receive them in time to fill out and return by the time the polling places closed on the Tuesday, I think April 7th. Primary gave rise, there was a lot of effort. The governor, the legislature, were they going to do anything? They didn't postpone the election. They didn't amend the statutes to allow for it. Litigation in federal court followed, in which a district judge issued a preliminary injunction saying, look, we need to, among other things, we need to extend the amount of time for folks to receive their ballots so that they can turn them around and get them in, and extended a period beyond election day in which the election officials should receive those and process those ballots. And we've seen that issue again and again. That was the first case to go up to the Supreme Court. In a per curiam decision, the Supreme Court said that the district court had overreached, that a federal district court was without authority to extend the date in that fashion. It was a 5-4 decision generating a dissent written by one of the final decisions by Ruth Bader Ginsburg, in which she called the ruling something that was going to lead to massive disenfranchisement for people who were going to be faced with, in her view, an untenable choice between braving the polls, risking COVID. Hundreds of polling places in cities like Milwaukee had closed for the reasons Sam just discussed, and that this was going to be a huge problem. For the per curiam, however, for the majority, there was a view that federal courts ought not to be intervening so close to an election, and that federal courts ought not to be deciding things that were ultimately for the states themselves to decide. And we've seen that issue come up in various jurisdictions, both decided by state courts and federal courts. And we'll talk about the Pennsylvania case, which is obviously one of the most important at the moment. But I'll just say a couple more words about this issue in the general election cycle. And I'll say it through the lens of the Wisconsin case. Again, when fall came around, same case, same district judge issued again an extension for the counting of ballots in Wisconsin. And this is a case that was resolved by the Supreme Court just last week, not very long ago. District Court again extended the time, and this time the appellate court stayed that order. Supreme Court refused to displace that stay. In a decision, and no opinions, but no opinion for the court, but a bunch of individual opinions from various justices, which the Chief Justice in particular said, we are not going to intervene. Federal courts ought not to be intervening. And I think a particularly telling, it's gotten a lot of press from Justice Kavanaugh, but actually Justice Gorsuch's opinion that I think captured the reluctance on the Supreme Court, and the majority of the Supreme Court right now, to be second guessing. And what Justice Gorsuch said well, how much is enough? How much should Wisconsin do, or any of these states do? How many days is enough days to um, extend the time for which we're going to receive ballots? How many polling places do we need? How much space do we need in a polling place? Should federal courts be ordering more polling stations or additional social distancing measures? And he said this sort of in a way of saying, these are just not decisions that federal courts are equipped or should be resolving. These are for the legislatures. And I'll pause. I'll stop in just a minute to invite Sam to come in and talk about the state court iteration of these things. But I do want to offer this thought on where the federal courts wound up in all of these cases, with this view that these details about how to run an election in a pandemic are ultimately details to be resolved in the state by state legislatures, is, on the one hand, sounds reasonable, right? How do you know what the right ruling is? It's difficult to say what balance of practices are necessary, sufficient in this complicated world in which we find ourselves. At the same time, I think it's worth noting that the reluctance of the federal courts, and I think this has been a consistent theme that we've seen over the past several months, to intervene, to say, no, the constitutional right to vote requires these additional procedures. The insistence of the federal courts that hands off, we're going to leave this to the states, very often involves what it involved in the Wisconsin case, which is a displacement of a district court order that said, unless we modify these rules, unless we adapt these rules to the circumstances in which we find ourselves, there will be an undue burden on the right to vote, that the federal constitution requires this intervention. And in rejecting that, I think the court is very clearly putting forth a different understanding of what the right to vote is, a more circumscribed notion, a less robust notion than one that we've seen in foundational constitutional decisions, if not recently, going back a few decades, a decade or two now, to see where that was. So let me pause there, because these cases came, on the one hand, through the federal courts, enjoining federal court orders that tried to modify state rules. Pennsylvania case actually presents a different question, and an interesting question, and the one that may be teed up in the Supreme Court, and we'll see what happens. So I'll invite Sam to kind of come back in here and talk about that.
Yeah, I mean, so it's really interesting, right? And I want to sort of pick up a little bit, Ellen, where you just left off. That, it seems like there is a majority on the Supreme Court right now that wants to say it's up to the legislature to decide questions about how to manage elections, in general and in the specific context of a pandemic. And what exactly that means, we can talk a little bit more about. What it means that it's up to the legislature to do it. But the idea that this is not something the federal court should intervene in is pretty clear. There is a majority on that. And I think it does bear some emphasis that the context in which this arises is, an incredibly high stakes moment, right, which is a presidential election during a pandemic, which is, if not completely unprecedented, certainly a once in a century kind of phenomenon. That was certainly not anticipated at the time that the various statutes creating election administration rules were adopted, and that this issue arises right now at a moment of extreme polarization within state governments, and particularly the governments of the states that are likely to be pivotal in the Electoral College, right? States like Wisconsin, states like Michigan, states like Pennsylvania. And so it's not like the ordinary legislative process is likely to spit out something that's going to be responsive to the current pandemic, because that's going to be perceived as helpful to one side and harmful to the other. And it takes both sides to agree in states with divided government. And where the stakes are this high, they just won't agree. But the constitutionally protected right to vote is always there. And what the federal courts in these cases are saying is, look, if the legislature isn't going to step up, obviously we prefer if they stepped up, but if the legislature isn't going to step up, then we have to craft some way of accommodating the existing statutory scheme to the current pandemic in the light of the fundamental right to vote, to make sure that the fundamental right to vote is not unduly burdened. And in Pennsylvania, we saw the state courts essentially doing that with the question of when absentee ballots could be counted. Doing that, however, in the context of interpreting their own state constitutional provisions. So instead of saying that, the federal constitution provides a fundamental right to vote, or at least a fundamental right in the sense that it can't be taken away unequally or it can't be unduly burdened, here it was the state court saying the state constitution imposes this right. So if you feel like the states should decide instead of federal entities like federal courts, then you might say, well, okay, let's let the state court decide. And in fact, in Pennsylvania, the Pennsylvania Supreme Court said, look, any ballot that is returned, that is put in the mail before the end of election day, even if received a couple days after election day, has to be counted, because we believe, whatever the statute says, that the state constitutional right in this context requires that the statute be interpreted to allow counting of a ballot that is submitted by the deadline but received later. So the state did that, and the Supreme Court, before Justice Barrett assumed her position on the court, declined to stay that ruling, declined to set it aside, with Chief Justice Roberts flipping essentially from the position that he had on the Wisconsin litigation and explaining that, well, there's a difference between when a federal court tells a state to do something and when the state's own court tells the state to do something, a difference of federalism that matters. There is, however, this lingering issue, which may end up getting fought out in the federal courts and the Supreme Court, and in fact, in the very same case, involving whether a state Supreme Court has the power to interpret a state constitution to override a state statute with regard to presidential elections. Now, normally, of course it does, right? Outside of presidential elections, we have no doubt about this. The state constitution is the only thing that gives the state legislature the power even to adopt legislation. It necessarily limits what legislation a state legislature can adopt. But there's been this argument floating around ever since 2000 and the Bush v. Gore litigation in Florida and getting to the U.S. Supreme Court, that when the U.S. Constitution says the legislature of each state shall decide how presidential elections are conducted, what that means is the state legislature, unconstrained by any other actor, including the process created for legislation under the state constitution. Now, there are a lot of reasons why I would say this is an extreme argument, and actually one that kind of fails logically. But I will say it seems likely, based on reading the opinions of the individual justices, that there are at least 4 votes for that proposition on the U.S. Supreme Court now. So if the Pennsylvania outcome turns on votes that were received after Election Day, and the Pennsylvania outcome is pivotal to the presidential election this year, I fully expect to see litigation in the U.S. Supreme Court about whether those ballots that were received after Election Day should be thrown out, even though the Supreme Court declined to issue such a ruling before Election Day. That's only one of the post-Election Day issues we're likely to see. And we just have a couple more minutes, but I wonder, before we open it up for questions, but I wonder if Ellen has any further litigation issues that we're likely to see, like perhaps the cases that were filed today in Michigan and elsewhere.
Yeah, I do want to say a thing about that, but I actually just want to respond to something you just said about the curiosity of this independent state legislature doctrine and the notion that the state legislature might be acting independently and have a right to act independently of state Supreme Court review, or in fact, independently of discretionary judgments by state election officials to cure mistakes in ballots, which is also another lawsuit we saw yesterday, filed yesterday, hearing today in Pennsylvania. Not clear that it's going to advance. The judge expressed some skepticism about whether discretionary conduct by an executive official is itself usurping the power of the legislature. But I was thinking about what you were just saying about this idea of the legislature setting forth the rules in advance and not necessarily anticipating or being able to anticipate the situation in which we find ourselves in, and how I share your skepticism about the doctrine, about this line of argument, but in fact, how it might itself collapse upon itself in a way that restricts the power of the legislature. And let me try and say that a little bit more clearly, or a little bit with more detail. If the legislature adopts an election code, rules to govern the election, with the expectation that those rules will be subject to judicial review, that those rules will be implemented by election officials exercising some degree of discretion, precisely because every contingency can't be anticipated, to now come in and say, no, it's exactly what you wrote down, and it must be strictly construed with no deviation, is itself, I think, could be argued at least, usurping the power of the legislature to have its code implemented the way it anticipated. Like you, I think there are 4 justices who have expressed quite a lot of sympathy for the notion that the state Supreme Court in this case usurped the power of the legislature. We don't know how Justice Barrett would rule on the question. The Chief Justice has indicated he doesn't subscribe to it, at least in this case. And we'll see what's going to happen. And like you said, there's some hope that it won't happen, in the sense that it won't turn on these specific ballots. There are a bunch of other lawsuits. We don't know exactly what's going to happen with them. Cases filed today by the Trump campaign to stop counting in Michigan, and there were some issues today in Detroit about an effort to stop the counting of ballots. There's been an indication of a call for a recount in Wisconsin. And the details of these, we don't yet know exactly how this will work out. And if there are disputed questions going forward in terms of the certification of electors, there are all sorts of possibilities that we might see. I know there's some questions. I want to just flag, I guess, or offer some thoughts, and ask Sam to do the same thing, about thinking about roads ahead, where we're going to find ourselves if, as things look now, it stays the same way. If we see, perhaps the Senate staying in Republican hands, the presidency moving into Democratic hands, what's going to happen with that division and how we're going to go forward. And I just want to offer, one thought to just start us out here. The ability, I am pessimistic about the role of federal courts in vindicating expansive views of voter rights, in playing a role that will make it easier for voters to participate, and as a place in which obstacles to some of the, as a place in which the obstacles we've seen that many voters have been confronting will be displaced. The federal courts are not going to play that role. And so there's a question if we should want to improve the voting system, make voting easier. No one should wait in line 8 hours to vote. I think that should be something we all agree upon. What are we going to do about it? And I just want to point to efforts at state law. And Sam flagged this. In 2018, we amended our constitution here in Michigan to make voting easier in critical ways, with same-day registration, with automatic voter registration, with absentee ballots on demand. And we've seen this time around things we still need to do about the counting of ballots that are submitted before Election Day, about accommodating ballots that might be arriving later, and many other things that we could do. So one place to look, I think, is in state law to improve matters. Sam, do you want to talk about that, or should we look at some questions, or how do you want to proceed?
Yeah, well, so it's about 6:36. So why don't we take some questions right now? So I see a few questions. So the first question I see is, on which legal grounds can mail-in ballots be challenged? And so the basic argument that has been made in these cases. I mean, obviously individual ballots could be challenged on a whole bunch of bases, like the signature on the ballot doesn't match the signature that's on file with the voter registration official, for example, or the person wasn't eligible to vote or wasn't eligible to vote absentee in a state where that's not something everybody can do. But the big, those are individual kinds of issues. The big litigation here has been around this question of the receipt deadline. So in a lot of states, not every state, but in a lot of states, there is in statute a requirement that mail-in ballots be received by the election officials, whether it's a local clerk or whatever they're called, by the end of the day on election day. And it's not true in every state. Like many of you may know, in California, it often takes weeks actually for the final results to be released. And sometimes that's very consequential in a lot of down ballot races, right? We don't know who's won a lot of down ballot races in California until long after election day, because they will, as a matter of state law, accept ballots that are sent in by election day, and it can take a while for those to be received. But in states that have a deadline of received by election day, in normal years that might work, but in a year like this, with the issues we've had with the Postal Service, plus the massive crush of additional absentee ballots, what we found in the primary, at least the various primary elections, was that there were a lot of people who did everything they were supposed to do, who submitted their applications for mail-in ballots in a timely fashion and returned them in a timely fashion. And their ballots got in late, not through any fault of their own, but only because of delays in the mail. And what a lot of courts said is, look, if a voter's done everything they're supposed to do, then they shouldn't be bound by the deadline in the statute, by the received by deadline in the statute, which isn't in their control. And what a number of other courts have said, going up to the Supreme Court, is no, you really can't do that. As Ellen was saying, how are we supposed to know how long they're supposed to extend it for? It just seems like a very non-judicial kind of determination. Now, I don't think so. I think judges actually make decisions where they draw lines like that all the time, but you can see the argument that they're making, that essentially this is not a place for courts, and we're going to see that, and the version of that we're going to see in Pennsylvania, if Pennsylvania is close and if Pennsylvania is pivotal to the outcome, is that the state court didn't have the power to override what the legislature said because of this Article 2 argument. And that's going to be the big basis for that. I don't know, Ellen, if you want to say anything about that or take another one of our questions.
I think you covered it. So I'll take the next question, which is, how is Justice Roberts' federalism reasoning consistent with Bush versus Gore? On the one hand, it's not, in the sense that there were only three, the independent state legislature doctrine was not the court's holding in Bush versus Gore, but rather a concurring opinion in Bush versus Gore. 3 justices signed on to that. It was not, they never got a majority of the court. But I think it actually can be understood to be consistent in a more narrow sense. One can say that this doctrine, one can just disagree with the doctrine and say there is no such thing as the independent state legislature. The state legislature necessarily acts with, the laws need to be signed by the governor. The laws are subject to judicial review by state courts. The legislature is necessarily bound by the federal constitution, obviously. And so there's the question whether there is the doctrine at all, or sort of a more refined version of it, which is to say, of course, the state legislature is subject to judicial review, but there are times when the state Supreme Court is acting in a lawless fashion, is acting or doing something that's understood to not be reasonable judicial review, but instead just making up another election code. And I think there was a belief, at least among the justices in the concurrence back in Bush versus Gore, that that was what the Florida Supreme Court was up to. I happen to disagree with that assessment of what the Florida Supreme Court was up to in that case, but that judicial review in the normal course is possible, but not in an extreme way. Who's to say what falls outside of that realm? And so perhaps the Chief Justice thinks there are differences in the way the state Supreme Courts have acted in these relative cases, and that whatever happened in Florida in 2000 is different than what's going on with the Pennsylvania Supreme Court right now. And I think it is worth to flag one other issue, which is going to have ramifications beyond this election. And that's a decision from four-ish years ago now, in which the Supreme Court upheld Arizona's independent redistricting commission. And we don't have time to go into the analysis there, but driving the argument in that case, and what was ultimately the dissenting position in that case, was an argument that looks quite similar to the independent legislature doctrine that we're talking about here, under Article 1 of the Constitution rather than Article 2, because we weren't talking about presidential electors, but can a state independent redistricting commission draw the lines for congressional elections when the Constitution itself speaks of the power of the legislature to set those rules? And what's telling about that argument, and I think curious where the Chief Justice is ultimately going to come down, he doesn't seem at the moment to be sympathetic to the doctrine's application in the context of Pennsylvania. He dissented in that case about the Arizona Redistricting Commission and quite vehemently thought it violated the state legislature's power. And that's important because the commissions at the moment are seen by many people as one way to get us out of this partisan redistricting morass. And Justice Ginsburg wrote that opinion, and Justice Kennedy joined it. So the majority for that court, that opinion no longer exists, or at least I think there's reason to think it doesn't exist anymore. So we'll still see playing out in the future now how the Chief Justice navigates his apparent belief at the moment, his stated belief that the Pennsylvania Supreme Court's decision should stand, whether he will ultimately view something different going on in the partisan gerrymandering case, which was, I guess, a bit of a long-winded answer. Sam, do you want to take, I can just flag this thing about what happens if it goes on past September 8th. There's actually whether litigation goes on past September 8th. Sam referred to this as a safe harbor. Jurisdictions don't have to, states don't have to take advantage of the safe harbor. They have about a week after the safe harbor date to continue to resolve it. There would likely in that case be a dispute about what the valid slate of electors are.
So this next question is actually posed directly to you, Ellen, which is Ellen, could you elaborate on the Michigan case brought or threatened by Trump, and what is their gripe, and is there anything to it? I'm happy to talk about it too, but
yeah, why don't you go ahead, because I'm not sure the answer to that.
Well, I did happen to read the complaint this afternoon, so what they are saying, this is a lawsuit that was very hastily drafted, and if you look at the complaint, you can see it's very hastily drafted. Although it was drafted by a very prominent national lawyer for the Republican Party in various, electoral disputes, and what they say is, look, there's a state law that requires that when votes are counted, there be both a Republican and a Democrat present in each precinct, essentially. And the absentee voter counting board is essentially treated like a precinct. And what they said is there weren't enough Republican election officials who were there, or Republican election judges who were there at the TCF Center in Detroit. And they also said that Republican election challengers weren't allowed in. If you actually look at the video of what happened, it's clear there are dozens of Republican election challengers in the room. And then there are also many, many more Republicans outside of the room who are pushing to get in, who are being kept out. But I don't think there's any basis for the claim that Republicans were kept out of the room to count the votes. And the idea that that would somehow lead to stopping counting the votes There's no basis that I can see for that relief. The case is in front of the State Court of Claims right now, unless it was ruled on, since we've been in this conversation, which I kind of doubt. I imagine it's still pending. But realistically, the count at the TCF Center and in this state is likely to end sometime this evening. I mean, actually, in response to some difficulties in doing counting of ballots in the primaries, the state election officials in this state worked really hard to make sure that there was capacity, particularly in big jurisdictions like Detroit, to do a count of absentee ballots as quickly as possible. And I think they've done a quite good job at that. Obviously, this is a big, massive process, and there are always going to be errors here and there. But I think they've done a terrific job of really professionalizing the process. And so I think this is likely to be just sort of a sideshow. But I think it ties into the previous point in the sense that if what you want is for the results not to be certified by the safe harbor date, what you might do is file a lot of litigation to try to slow things down. And this looks like the kind of case that is more likely to try to slow things down than it is to actually prevail in the end.
I will read the next question since I have nothing to add to that. And it comes from Rebecca Scott. It's nice to have a faculty meeting. Given the fact that the 15th and 19th Amendments frame the right to vote in negative terms rather than positive terms, and that the Voting Rights Act has been damaged, do we need a federal constitutional amendment conferring an affirmative right to vote, and might that be helpful? So, great question. It's not the first constitutional amendment I would push through if I thought we had a chance of pushing through a constitutional amendment, which I don't feel very confident about its likelihood. So of course, the sort of foundational amendments that we think of, barring abridgments of the right to vote on the basis of race, on the basis of sex, don't actually grant the right to vote to anybody. And it's famously said that the federal Constitution does not give anybody the right to vote. But there are, and we have come to understand under the 14th Amendment, that the right to vote is fundamental, and that where states provide the right to vote, they need to have, I'll say in a trivial way, certain bells and whistles to make sure that the right to vote is available in certain circumstances. So classic examples, no poll taxes in state elections. It's an impermissible burden on the right to vote. Requirements that you need to live in a jurisdiction for a full year before you can vote, too onerous in our understanding of what the right to vote is. And there's a whole bunch of cases, foundational cases that have understood this sort of, I would say, more robust conception of what the right to vote is. I'm of the view that that conception has really disappeared in the modern era in the last dozen years in a series of decisions that have really whittled it away down to something that looks much more like a bare legal right to cast a ballot, regardless of the burdens that a jurisdiction puts in one's way, so long as one ultimately can make it to the end of the process and cast a ballot, be it in the middle of a pandemic, having waited on a very long line, or any number of the iterations we've seen. No harm, no foul, so long as that legal ability is there. That's a way of saying, like, maybe you're right, we need a constitutional amendment. I don't think that's going to get, that's a big haul, not one that I see happening, not one that I'm all that sure will be construed favorably. I think there's a lot of room for ordinary legislation, at the state and frankly at the federal level, were Congress so inclined, that could do a lot to make voting easier, and that would be not that it would not necessarily be challenged, but I do think could survive review, particularly for federal elections, and that there are things Congress can do to make voting easier that Congress should do, and something that I would hope would be bipartisan in advance of an election, certain rules that we could agree that are necessary pursuant to Congress's power to regulate the time, place, and manner. So I'm rambling here a little bit, but the notion that yes, we could amend the Constitution any number of ways to change things from the way they are. And I think lots of people have lots of things they want to change about the US Constitution. It is not an easy thing to do. So let me stop there. And I don't know, Sam, do you want to pick one of these? There's actually too many.
Yeah, we have too many to answer in the short time that we have. Yeah, I mean, so let me answer this question that we have about on what grounds would the Trump campaign lawyers be able to file a lawsuit to request that Michigan stop counting the absentee ballots when they were received before 8 p.m. on 11/3, as required by federal law? Yeah, I mean, so I don't think there is a good argument there. You know, I mean, actually, in part, that's because the folks on the Democratic Party side of this litigation and of these fights lost a bunch of cases before the election, right? So before the election, a Democratic Party aligned organization filed a lawsuit that sought to extend the receipt deadline for absentee ballots until after Election Day, so long as everything was mailed by Election Day. And actually, they won an order granting them that relief in the lower state court, in the State Court of Claims. That order was relatively quickly reversed by the State Court of Appeals, and the state Supreme Court left the State Court of Appeals decision intact. So as of Election Day, the rule was that an absentee ballot had to be received by the clerk by 8 p.m. on Election Day. And that's why you saw this big effort, if you lived in Michigan, by the political parties to get people to return absentee ballots, not through the mail, but in drop boxes that were put up by their clerks, that counted as being received by the clerk. And, you know, for folks who wanted broader access to absentee ballots, they thought of this as a loss. I mean, it was a lawsuit that they brought that they lost, and it was sort of seen as deflating. But in fact, at this stage today, it's one of the best things for people who want to defend the result of the election in Michigan, where it looks like Joe Biden has beaten Donald Trump and Gary Peters has beaten John James, because now we know that anything that was received later was going to be rejected anyway. So all the ballots that are being counted now are ballots that were not just returned before the end of Election Day, but received before the end of Election Day. So there's really no good argument for throwing them out. It's just the ordinary counting process. You know, there are a lot of ballots. It takes a long time to count them. And one of the things that's important here is we all knew that there was going to be a very time-consuming process to count these absentee ballots in this state and in various other states. But it's a time-consuming process in part because, you know, when the clerk's office receives the ballot, they have to check the envelope they get. They have to cross-match the signatures. You know, they have to do various extra work to open the envelope and get things into tabulator machines. And the folks who were running elections wanted extra time to begin doing that before Election Day. In this state, one of the reasons why we're going to get results probably by the end of the evening tonight, in this state, the legislature agreed to, at least beginning the day before Election Day, allow the local clerk's offices to pre-process these ballots, not to begin counting them, but to match the signatures and take them out of the envelopes and get them ready to be counted. In some states where there was divided government, for example, Pennsylvania, the legislatures didn't do that. And so what that meant is you were necessarily going to have long delays in counting the ballots, even the ballots that were received before the end of Election Day. So yeah, that's just to be expected. And I think it's all going, you know, very professionally and as smoothly as it possibly can be going in terms of the actual counting. And there's a lot of increasing noise around the process, but the counting process itself seems to be moving as it's supposed to. I know, Ellen, if you want to take one last question, and then
one
we're
more,
probably done.
Quick answer, because you know, is there any chance of getting rid of the Electoral College? Seems useless and unfair. You know, that's a amending the Constitution thing again, which is tricky to get consensus and get something like that through. There's a proposal that's circulating for a while. The National Popular Vote Compact, where states would sign in and agree to award their their slate of electors to whoever wins the popular vote. And I think on last I checked, had about 15 states that had signed on, but we haven't gotten enough states to sign on. There would be a legal dispute about it, should that actually ever come to pass. And that said, I think there's an incentive for lots of states to not do it. It's not clear what states that benefit from the system and have what some feel is outsized influence get out of relinquishing that role. So it seems useless and unfair is a commonly shared view on it. A similar critique might be made of the U.S. Senate, given the disproportionate power it awards to certain to small population states. That said, it's baked into our system, and we've had it for a long time. Just not to say it shouldn't be fixed, but it's not an easy thing to fix. I think I want to add just one more thought from talking to my students yesterday, and I know I see my students working tirelessly to register voters, to help voters be able to cast ballots in this election. And I see among them, I've heard from them, a large degree of unease of what's happened in the last 24 hours. And I guess I want to offer this thought. Even if the election went or turns out to go exactly as you hoped, and I suspect there's no one for whom that will be true, even if it did, the work isn't done. The turnout was very high. It should be higher. And I guess I want to, just offer to say that my students leave me encouraged about the work that they do. They're pushing forward on this, and the work that they do when they leave Michigan. And our alumni from the law school go out and work in the Department of Justice's voting rights division, work in state government, administering elections, work for public interest groups litigating these cases, work for private firms that are litigating these cases. And I know they're going to keep fighting these things, and to think that we're going to be done, that this is something that you fix and then we don't have to think about anymore, I think is a misconception of what this project is. So even if you feel this unease at this moment and this discouragement, the sense is this is part of an ongoing process that we will always be working on to make the elections more fair, increase access for people who are encountering obstacles. And so hang in there and keep up the work. I think the good work that you all have been doing. You guys give me hope going forward, even when things feel a bit discouraging on lots of fronts.
Yeah, we have the best students at Michigan. I really mean that, in the sense that people who are just, so incredibly smart and engaged and really care about the world and about using the skills that we're giving them to go out and try to fix the things that need fixing in the world. And it is really amazing. I mean, the number of folks who are out there, even as law students, doing that, and certainly once they graduate. So that's been truly amazing. And in the world of fixing our electoral system, Lord knows we have lots of work to do. And I really appreciate everyone being here to hear us talk about all this today.